This is video 6 in our abuse and neglect module, and we're going to deal with the CCC, or Criminal Code of Canada, and how it looks at abuse. If your client is an adult, the Criminal Code of Canada applies to him or her in the exact same way as it applies to you. It really doesn't make a distinction based purely on whether or not the power differential we described in much earlier videos applies here. Instead, there's just a whole bunch of different crimes that describe the way that we act towards each other. For example, it's a crime to threaten people, to physically or sexually assault people, to harass people, not just sexually, but in many other ways, to defraud them, which means to get money from them through dishonesty or misrepresentation, to steal from them, to sexually exploit them, for example, to take pictures of people and sell them without their permission, or to deprive a person of the necessities of life. So that idea of depriving a person of the necessities of life could happen, for example, if we didn't let our wife go out and get food, and we abused our spouse that way. That doesn't only occur in, again, a situation where there is an adult-child situation or a caregiving type of situation. In terms of when we are not giving people what we need, the law thinks of that as of a crime called negligence, or behaving negligently. So again, this particular law doesn't particularly use the term abuse. Instead, it has a whole bunch of different names for specific crimes. And if you as a person in power commit a crime like that against an individual who is more vulnerable, the courts may deal with it in one or two ways. One of them is that they may use the term aggravated in front of that crime. And you may have heard this before, that a person was guilty of sexual assault and somebody else was guilty of aggravated sexual assault, which means that the Crown attorneys have felt that what you did was so bad or so serious that that word should be added, and the court should consider it an even more egregious crime, and therefore should punish it accordingly. Even if they don't do that, even if they simply charged you with simple sexual assault or simple assault, physical assault, a court, in terms of its sentencing, a judge or a jury, may find that there are reasons for that individual that has been charged to be punished at a higher level. So even if the crime was not necessarily called an aggravated crime, the judge can choose from a range of different sentences and may choose one that is more severe, such as the length of a prison term, or how bad a fine is, or how long a person's record may exist, or prohibitions, things that they're not allowed to do, such as being able to work in this field again. There are two ways that the law looks at the way we harm somebody. And we can think of them as acts of commission or omission. When we commit or commit a wrongdoing, we are intentionally acting in a way that will harm another. When we're talking about children, the law thinks of that as abuse. And as we've already said, those acts include sexual abuse, physical abuse, and emotional abuse. But even when the law is meant to apply to everybody in our society, and we call them crimes, those crimes get names like assault, sexual assault, theft, and threatening. None of these are accidental, and none of these represent an oversight. They're all things that people have actively done, and they've done with intent. The other category of offenses or harms is called omissions. Sometimes you'll hear people refer to torts, things that they didn't do that they should. The French word tort means wrong. Omissions are failing to take reasonable steps to provide for or protect the welfare of others. In this case, the intention of the person is not relevant. In other words, you could argue that they should have intended to do the right thing. In the case of children, the law calls that neglect. In the case of the legal criminal code, it's called criminal negligence, or failure to provide the necessities of life. And an example of this might be a bus driver who is supposed to inspect the brakes on their bus, but doesn't. And as a result, the bus has an accident and children are harmed. An interesting thing, if the bus driver is pulled over by, let's say, one of the commercial vehicle inspection officers, and it is found that they have not been inspecting their brakes, Even if the bus never had an accident, even if nothing bad actually happened to the children, that bus driver could still be considered to have committed, or sorry, have omitted their duties, to have not done their duty of care. That's another way we can put this, right? That the lack of duty of care is omission, and they can be charged with criminal negligence. So it doesn't have to result in harm. It just has to have evidence that a reasonable step was not taken. And neither does a person have to have done it out of any kind of ill will. Usually these types of acts or omissions of action are caused by a person not being mindful enough, not really being thorough in their thinking. So we talked earlier about poverty not being an excuse for neglect. You could also argue that things like being unwell or being drunk would also not be examples of why a person could be excused for omission. You're supposed to be being fit and well enough to do this stuff, and that's part of what your responsibility is in terms of your duty of care. Now, it's also important to understand that there are things beneath the law, more specific types of documents that we all must comply with. So the law, we've just talked about two of them, is important, but there are also things called regulations, contracts, and policies. So the Child, Family, and Community Service Act and the Criminal Code are a type of law called a statute. They're a written law. You could look them up right away online anytime. And they are considered the highest form of law or of enforcement. However, even if something isn't illegal, it might be contrary to the regulations. So regulations are the detailed explanation of the law. I'll give you an example. Every time you go to a restaurant, the restaurant is required to comply with some regulations that are stipulated by the health department. There's a law, and you're familiar with it already, and it's basically called, there's one called the Community Care and Assisted Living Act, and there's also a law that stipulates the same kinds of standards around the cleanliness and safety of any place that serves food, like a restaurant. And there are people called licensing officers whose job it is to go into those assisted living facilities and group homes and restaurants. And what they do is they bring with them a much thicker document than the law. And that document details all of the regulations, for example, the temperature of the refrigerator, or the cleaning products that are used, or the frequency of cleaning, or the fact that they document the cleaning. All of those things are examples of very detailed explanations of what the larger law stipulates. So what the larger law simply says is you are required to comply with the regulations, that it's your job to abide by what this licensing officer says. And the reason that they do it that way is so that the law is simple and not hard to change. If I want to change the regulation, I don't need to bring all of Parliament back and have them vote on all these little details, especially given the fact that all those politicians aren't going to be experts on the temperature of a refrigerator. So instead, people at the professional level usually design these regulations, and the whole bulk of them are approved by the government as being part of the law. Even if a matter is not prohibited by law or regulation, there may be another way that it is limited. And that is that when agencies have a contract with a funder, in this case, usually the Community Living BC, or schools with the Ministry of Education, they essentially got a contract with those funders. And the contract doesn't just say, please teach children or please run a group home. It stipulates in very clear terms the conditions that that's supposed to happen, sometimes referred to as deliverables and as limits, deliverables and limits. And so the funder reserves the right to terminate the contract if the service provider doesn't uphold the standards. So there's yet another level of accountability that makes community living agencies and school districts and all kinds of other funded agencies really kind of make sure that their I's are dotted and their T's are crossed. And in order to do that, most of the time, individual employers create a document called their policy manual or their policies. And the policy is very individual to that one organization. Let's say you decide to go and work for 2 community living agencies when you graduate from our course. Maybe you go to Mackle and then you go across the river and you work for, let's say, Home Society. Both of them will have a lot of commonality in their policy, but their policy documents will look different and will have a significant amount of differences. They'll have different ways that they do things and different expectations to some extent of their employees. So if you violate their policy, you might not have violated the law or even violated a regulation or even done something that would be contrary to a contract with CLBC. But you might be in trouble with your employer. You might actually be disciplined or lose your job because employers have the right to set an even higher standard or set of procedures for their particular agencies. So they could, for example, tell you that you are on probation, or maybe even that you are going to get dismissed if you didn't do what their specific policy indicates. And this is a little side note, but it's important to understand that a policy document is not the same as a collective agreement or a union contract. And neither is the contract in bullet point number 3 here. That's very different. Those contracts are about protecting the rights of employees and really have nothing to do with the conversation we're having here in this lesson. So we're talking about the contract the funder has with the agency, and we're talking about the policy manual that really is what gives you your marching orders and your limits. You have to comply with all of these in your work, all of them. And what you'll notice about them is that sort of the higher these things are, the more high in rank they are, the less specific or detailed they are. So the law, these statutes, doesn't really get into a lot of detail about what we mean by abuse or neglect or how to handle it when we come across it. But the policies where you work and the contracts and even the regulations have quite a lot of detail. They're just not as powerful. So that's sort of an interesting dynamic that happens. You have a legal and ethical responsibility under all of these. And so I'm going to say that again. You have a legal and ethical responsibility. They're not the exact same thing. To put it another way, you could break the law and not necessarily have done something unethical. So for example, let's say that you went out after a day of work and injected heroin. That's against the law in Canada. But if it didn't in any way affect your clients, then you haven't done anything unethical. On the other hand, you might have done something that wasn't illegal. For example, you might have called an adult client a swear word. That is probably going to be something that your employer will find against their policy because it's unethical. However, you shouldn't expect to be charged with a crime. So they're not identical. One of the most important things to understand, though, is that the law and your ethics require you to do a specific thing. And this is really the kernel or the core of this whole course. You have what we call a duty to report any suspected abuse or neglect. Please highlight that idea or really make sure you understand the key concepts there. You'll see that the word suspected is underlined. So we really need to be clear on what we mean by suspected. We only need to know whether we have a suspicion of abuse or neglect before this responsibility kicks in. And when it does kick in, it kicks in the form of making us report abuse or neglect in a very specific way and not investigate. We are not investigators. And there's a very important reason why we shouldn't investigate, and that is that if we investigate, we will actually make things worse for the person who is likely being abused or neglected. How so? Well, there are 2 ways. First of all, when we investigate, we often alert the person who has been suspected of abuse or neglect, and as a result, they begin to do things to cover their tracks. For example, they destroy evidence, they flee, or they threaten the person they have abused. And sometimes they even will turn the story around and accuse you. The other thing that can happen when we investigate is that we can taint the evidence. We can poison the evidence, so to speak. So that if a person has to testify or a child is interviewed by a social worker and we have asked the wrong questions or said the wrong things, then the defense of the person we have accused or who becomes accused can use that as a way of weakening the evidence. They can suggest that the child said the things that they said because we put them in their head, or because we rewarded them with a hug or a candy or attention for doing that. So it's very important for us to stop at the point where we have a suspicion. Now, there's going to be a little bit of difference in every scenario of what creates that threshold or point at which we would say we are suspicious. It might be that our own personal barriers or boundaries are a little bit different than the next person. And it might also be the amount of evidence that we have. It really is okay for you to report it even if other people aren't at the point of being suspicious. In fact, the law says you must do it when you would basically answer this question: am I suspicious? Am I suspecting something? And if the answer is yes, you must report it to a child protection worker. And that is as simple as it gets. Now, you cannot tell somebody else to do that for you. Let's say that 2 or 3 of you are working on shift and you all see evidence that you think constitutes abuse. All 3 of you must report it. You cannot say, hey, why don't you do that for the other 2 of us? Neither can you go to a supervisor and have them do it for you, or be talked out of it by them unless they can give you information that removes the suspicion. So if you go and you speak to a supervisor and the supervisor says, oh yes, I saw Mike get that bruise when we were playing softball. His black eye really did come from the story he told. Okay, now you might decide that your suspicion is no longer warranted and you might not make the call. However, if you go to your supervisor and your supervisor says, I don't think we should call because we've called before, or because I don't want to do the paperwork, or because I just don't think this is big enough from my perspective, you are not legally absolved of your duty unless you are no longer suspicious. You cannot decide not to report because you know somebody else has already done that, or because you know that it has been reported previously, or if you believe that somebody has already started to take action. And the whole rationale behind this is, if you're investigating abuse, you want the most evidence you can get. You want to know whether or not other people are corroborating what you've heard from a first reporter or a second reporter. So it's really important that you understand that you don't investigate, that you report at the point of having suspicion. So how do you report it? Well, the first thing that you do is make sure that you and the child are safe. Now, you don't need to do this in a way that's confrontational. Let's say you walk in a scenario where you think that an individual is being assaultive and angry towards a child. You don't need to go in there and threaten that person or physically be in the middle of it and take the abuse directly yourself. Instead, you sometimes will have opportunities to do things that might be subtle, such as calling the child into the other room under a different pretense. So if you can do that, you should do that. And remove yourself and that other person from the situation that you believe is potentially abusive. Here's another example. Let's imagine that you have a child who tells you they don't want to go home after school because when they go home, their stepfather hurts them. You might keep that child after school while you make the phone call to the authorities and take guidance from them on what to do next. You must comply with the standards and expectations of your job. So whatever your policy is, you need to make sure you do it. And I can almost guarantee you that your policy is going to include telling your superiors. So remember, while your superiors can't just tell you not to do this, you do have to have a communication with them. You do have to remember that they may have information you don't. They are your superiors for a reason. So you should document it as well. You should make sure that you do whatever is expected to maintain the safety and wellness of everybody in your care. So you can't, for example, neglect the other 2 or 3 people in your group home while you're attending to the the abuse concerns you have about another one. So you have to do all the stuff that is meant to keep your client and you well. You should call 310-1234 if it's during business hours. And you can always call what's called Inquiry BC. You can look it up online, or if you have an old phone book around, not very many of those anymore, but the Blue Pages includes that phone number. If the matter is urgent, if there's an angry person, or if there's an injury, or if there's a threat to an immediate threat to safety, then you want to call 911 as your first priority. Notice that I did not say call your supervisor before you do those things. If there's an urgency before this, you must call your supervisor after you call 911. If it's not urgent, then you may wish to speak with your supervisor first. That's a pretty good idea. Do not confront or question the person that you believe may be abusive. Do not report anonymously. They will protect your confidentiality on the other side of the phone. But do maintain confidentiality toward all parties. It's very tempting to go and talk to your colleagues and share what you've gone through or to ask them questions. And you shouldn't do that after you've arrived at the conclusion that there is suspicion of abuse. So let me be clear about this. You're working on shift and you see that a child has a black eye. He says that he got it on the swing set in the morning. You know that another staff person was supervising the area where the swing set is. So you go to that person and ask, did you see this person fall off the swing? You have not violated what I have said, because at this point you have not developed suspicion. You're simply asking a reasonable question. But let's say that staff person says, no, he had the black eye when he came to school this morning. Now, the fact that he didn't tell you the truth might give you even more reason to be suspicious. At that point, you must stop having the conversation with the person who was supervising the playground, and you might go and involve your supervisor, but you're not going to engage in lateral conversations. So, inform your superiors and document. Complete and submit a critical incident report as soon as you can do so safely. Promptly, accurately, and thoroughly document what you observed. You may have nothing more around besides a napkin or an old receipt, but you should write in an accurate or as objective a form as you can what you saw and heard. So for example, if a child uses a term that is not professional sounding, you still want to use the term the child used. And here's an old story that sort of demonstrates why. Many years ago in the state of New York, a couple of parents were being charged with sexual assault against their child. The father with directly sexually assaulting his daughter, and the mother with allowing this to happen. They went to court, and as I mentioned earlier, the defense attorney tried to convince the court that the daughter had been sort of led to say certain things. But very wisely, the social worker had recorded the word that the daughter used to describe what happened. And the word that she used was hiney. She used the word hiney to refer to her genitals, to her vagina. And that was a very unique use of the word, because the word hiney doesn't normally mean that. It's normally slang for a person's rear end. However, the court observed that the parents used the term the exact same way as the daughter. Nobody else did. The social worker didn't use the word that way. The fact that the social worker had recorded that word gave credence to the allegations of sexual abuse and led to the conviction of the father. So it's really important for us to use the terms that the person uses. If they said it 3 times, note that they said it 3 times. If they cried for 10 minutes, note that they cried for 10 minutes. And I've been in circumstances where it was possible for me to subtly collect visual evidence. For example, I had an individual who had a bruise on his bicep, and I asked him to flex his muscles, and we took a picture with not just him in it, but a few others, and as far as he knew, we were all just doing a fun photo, but I had captured the size of the bruise in doing so. Another thing you might do is seek that person some medical attention, such as visiting an emergency ward. And this is not only necessary in cases of physical abuse, but where you suspect a person might have been sexually abused as well, because often they can collect evidence that may not be obvious to the naked eye, DNA evidence and so forth. So make sure that you keep accurate records, even if they're not looking like they're super fancy. Something as simple as that napkin written down, and you can say, I wrote it down at the exact moment the person told me this, gives what we call verisimilitude, or a sound of reality to what you're saying. Remember that you are not an investigator. That should be left to the ministry worker, and therefore you should act quickly in getting that person informed. Don't be surprised if the person at the other end of the line doesn't seem shocked and dismayed. Remember, they hear about this sort of thing tragically all day, every day. Remember that an untrained investigator will weaken the evidence and may warn the alleged abuser so that they start covering their tracks or threatening people. Avoid saying things that may cause anybody to lead the victim. Don't put words in their mouth or ask closed-ended questions. In fact, don't ask questions at all after you've established that level we called suspicion of abuse. And don't have a strong emotional reaction. While it's important to meet the emotional and physical needs of the person, for example, if they're crying, to bring them a Kleenex, giving them a lot of coddling can later on be interpreted as you doing something that led them. And in some cases, if we have a super strong reaction, we can actually create trauma for the person. Do show basic empathy to the person. Keep him or her safe and comfortable, and document anything the person says or does. And where appropriate, get the police and or medical people involved so that they can help collect evidence. If you come across a scene where there's been, for example, a struggle or a fight, don't clean it up. Don't just take pictures. You want somebody who's a professional investigator to come and see that. As I said, who should you call? The Child Helpline at 310-1234 is open 24 hours a day, or you can call the local office during business hours and they'll refer you. I also talked about Inquiry BC. If it's urgent or after hours, you can call the police. They will tell you what to do. If the person is a person in care, you need to make sure that you call the CLBC worker or MCFD worker. If in care means if they are in a program that is funded, and you call your supervisor. Before you call the family, you must always get direction from the child protection worker and or the police. And that includes circumstances where you do not believe it was the family that did the abuse. You don't notify them that you think their child has been abused. You let the professionals do that because they have reasons to do with the legal soundness of the investigative process, and they also have expertise in doing this. So in most cases, they will take on the role of making that contact.